Just plunge in.
I have the pleasure of introducing Michael O'Hare, and the topic today will be science and criminal sentencing. Michael O'Hare teaches criminal law at Marquette Law School in Milwaukee, Wisconsin. He's a graduate of Yale Law School. He practiced civil and criminal litigation in Chicago before joining the Marquette faculty in the year 2000 and served as the law school's first associate dean for research from 2008 to 2015. He's the author or co-author of 6 books and more than 80 scholarly articles, mostly in the areas of criminal procedure and sentencing. Welcome, Michael. Thank you for joining us, and the screen is yours.
Okay, thank you so much for that introduction and welcome. I'm really delighted to be here with you today. And I especially need to extend a thank you to your colleague, David Franklin, who's been a friend for a very long time. I was actually a Rotary Scholar there in Montreal about 3 decades ago. And David really was an absolutely phenomenal host for me while I was there in Montreal. He showed me around the city, he welcomed me into his home, took me to some of his favorite restaurants. I'm just extremely grateful to this day for the warmth and hospitality from David, and we've remained in touch over the years, and I'm very pleased to be able to call him my friend. David, of course, is the person who suggested that I be with you here today, so it gives me another reason to be in his debt. Well, as indicated in the introduction, I've been a law professor for about 20 years. And in that time, my main area of scholarly research and writing has been criminal sentencing. This is an endlessly fascinating topic, which has given me an endless series of things to write about. When I speak to non-academic audiences, and for instance, I did speak to our local Milwaukee Rotary Club a few years ago. When I speak to non-academic audiences, I normally speak about the topic of mass incarceration in the United States. And that's probably a term that you have heard at some point. You are probably aware that in the late 20th century, the American prison population grew explosively and to this day remains extremely high by comparison to pretty much any other nation in the world. So I find this topic to be of great interest to non-academic audiences. But this is the first time I've spoken to a non-American or not from the United States, a non-academic audience. So you guys in Canada seem to be doing things much better with your incarceration rate, which is only 1/6 the size of the US incarceration rate. So I thought a new topic would be in order for today. So I assembled a new presentation. And actually it's 3 separate topics that I want to put under the umbrella heading of science and sentencing. So these are all developments in the areas of science or technology that either already are having a large impact on sentencing or maybe having a large impact in the near future. And I believe all of these topics to have some relevance to Canada. So more specifically, my 3 topics today are number 1, actuarial risk assessment. Number 2, the use of neuroimaging evidence at sentencing. And 3, the use of intensive electronic monitoring of people charged with or convicted of crimes. And I'll tell you that I'll spend the bulk of my time on the first topic, actuarial risk assessment, in part because this is what's real today. This is an extremely widespread day-to-day use in criminal justice, not only in the United States, but I understand in Canada as well. So some background here. When we are thinking about risk assessment in the criminal legal system, we're thinking about the risk that an individual charged with or convicted of a crime will reoffend, will be responsible for a recidivism event. So recidivism is a commonly used term for a reoffense And there's no question that that risk assessment has been an important part of the sentencing process for centuries. In the traditional approach to sentencing, the judge has to make an assessment of risk really based on gut instinct as much as anything else. The judge will try to determine, is this defendant who I'm sentencing now, is this defendant somebody whose criminal conduct was an aberration and who is unlikely to commit another offense, or is this the so-called hardened criminal who is likely to offend again and again and again in the future? So this has always been part of the sentencing process, but as I said, usually on the basis of the judge's gut instincts. So this kind of a decision made on the basis of gut instincts is like a whole lot of other decisions in our contemporary world that are being made less and less on the basis of gut instincts and more on the basis of systematic data collection and analysis. So we know data analytics are in widespread use now, for instance, in the fields of business and politics. For example, businesses are using a large-scale data analysis to target their marketing messages ever more successfully in an ever more fine-grained fashion. Or another example of systematic, sophisticated use of data is Moneyball. That's a popular movie and book. I imagine most of you have some familiarity with that. It's the story of how the Oakland A's baseball team, small market team with a very low budget, were able to be consistent winners over a period of many years, surprising many people. And the secret to their success was Moneyball. In other words, the use of data and computer-driven data analytics to identify players who were undervalued in the market. So the A's picked up a lot of cheap players who ended up being very good. So I like to think of actuarial risk assessment as, in effect, Moneyball for criminal sentencing. So it's based on systematic use of data to make better informed, more accurate predictions of defendant recidivism. So it's not just based on the judge's gut instincts anymore. More specifically, how is this done? The judge at sentencing will be provided with the results of an actuarial risk assessment. This is using an algorithm or risk assessment instrument. What is done to create the algorithm is that data is collected on a huge number of past cases, maybe tens of thousands of cases, and computer analysis is done to determine what variables correlate in these past cases with recidivism. So for instance, a lot of research now shows that one of the common correlates with recidivism is age at first offense. So the younger a defendant is in beginning his career in criminal offending, the more likely that criminal offending will persist much later in that individual's life. So that's a well-recognized risk factor, the first age of offense. And then after correlates of recidivism are identified, some kind of a form is created, which will involve asking a number of questions about the defendant. And based on the number of risk factors that the defendant has, a risk score will be assigned to the defendant, and that will be associated with a risk classification. So to give you an example, in our federal courts in the States, an instrument called the post-conviction risk assessment is commonly conducted. This involves a questionnaire with 15 questions on it that will collect important information about each defendant's risk factors. So just to give you a sense, I won't read all 15 factors, but to give you a flavor of the kinds of information that would be collected in a risk assessment instrument. The federal PCRA includes questions about the number of prior arrests, age, alcohol problems by the defendant, drug problems by the defendant, whether the defendant is married or not, because the data shows that unmarried defendants are at higher risk of reoffense, whether the defendant is unemployed or not, because again, the data show that an unemployed defendant is at higher risk of reoffense, and so forth. And based on the number of risk factors that are present, the defendant is assigned to one of 4 risk categories: high risk, moderate risk, low moderate, or low. And research shows that these categorizations are meaningful. Defendants who are classified as high risk reoffend 64% of the time. Those classified as moderate risk reoffend 49% of the time. Those classified as low moderate reoffend 29% of the time, and those low risk reoffend 11% of the time. So, so when the judge, the federal judge, gets this information about a defendant, it is meaningful. It is giving the judge useful information about risk of reoffense. Now, I generally have a favorable view of actuarial risk assessment. The research shows that the actuarial risk assessment classifications are more accurate than the judge's traditional gut feelings would be. But there are a number of caveats that should be kept in mind with actuarial risk assessment. Some aspects of this phenomenon that tend to be downplayed or disregarded by proponents of actuarial risk assessment. And there are a lot that I could highlight for you here, but in the interest of time, I'll just focus on one issue in particular. It is very important for the judge to be aware of what exactly the risk is that is being identified with the actuarial risk assessment. And in most risk assessment instruments like this federal PCRA I was describing, the risk that is being detected is the risk of rearrest for anything, for any reason at all. So the bulk of recidivism events, in fact, are relatively low-level criminal offenses. For instance, a nonviolent theft, or low-level drug distribution, or disorderly conduct in a public place, things like that. And major violent crimes are actually pretty rare as recidivism incidents. So murder, sexual assault, non-fatal shootings, armed robberies. When criminal defendants reoffend, it's usually not these super serious violent crimes. It's usually much less serious non-violent offense. So when we throw around terms like high risk, it's very important for judges and really everyone to be aware what exactly the risk that is that's being predicted. And I do fear that too often when judges find out that a defendant is classified as high risk, that the judge leaps to the conclusion that this judge is going to do something absolutely horrific if the defendant is going to do something absolutely horrific if the defendant is not incarcerated. With that PCRA instrument used in the federal courts, for instance, the research shows that people classified as high risk only reoffend violently 21% of the time. So 64% of the time they're rearrested for something, but in only 21% of cases is it a violent offense. So it's a 1 in 5 sort of risk of a violent offense. And the violent offense might even be a relatively low level violent offense, a shoving match with somebody, or a routine bar fight, that kind of a thing. So, so I do fear that the use of risk assessment instruments can lead to unnecessary incarceration if it is not fully appreciated what is being predicted with the instrument. And I would be remiss in discussing actuarial risk assessment if I didn't also say something about what is the doubtlessly, at least in the States, the single most controversial aspect of actuarial risk assessment that has produced something of a political backlash, and that is the racial dimension of the use of these risk assessment instruments. In the States, and I don't know if the same problem exists in Canada, but in the States, on average, Black defendants have higher risk scores than white defendants do. So there is a real concern that the use of risk assessment instruments may exacerbate racial disparities in incarceration, which, as you probably know, are already quite bad in the United States. And I certainly think this racial justice concern is something that practitioners and policymakers should keep in mind. The folks designing risk assessment instruments also need to continuously be trying to minimize racial disparities created by those instruments. On the other hand, I think some of the racial criticisms are overblown, and I think there are a number of issues that could be raised, but I'll just focus on one. When we think about the racial effects of a risk assessment instrument, it's important that that not be considered in isolation. It's important to think about what the alternatives are and whether the alternatives actually do any better from the standpoint of racial disparities. And what's the alternative? As I mentioned earlier, it's the traditional gut instinct approach, and the judge's gut instincts are certainly apt to be influenced, at least at an unconscious level, by racial stereotyping. So it's possible that the risk assessment instrument does no worse with respect to racial disparities than the alternative. Maybe it even does better. And in fact, while there's not been a lot of research testing this comparison, this comparative performance on racial disparities, the research that has been done does indicate that the actuarial risk assessment instruments do no worse and possibly a little bit better than the traditional gut feelings approach. Well, I'd like to move now to the next topic, which is the use of neuroimaging evidence at sentencing. And I'll have a bit less to say about this, in fact, quite a bit less to say about this than actuarial risk assessment, in part because I certainly claim no expertise in the underlying science. But when we talk about the use of neuroimaging evidence, we're talking about something that is in some use today in practice, but not nearly as widespread use as actuarial risk assessment. And as with actuarial risk assessment, neuroimaging evidence is being used in an attempt to make decisions that were previously gut instinct sorts of decisions more scientifically grounded. So for a long time, much as dangerousness has been considered as a sentencing factor for a long time, or risk, mental impairment has been considered as often as a mitigating factor at sentencing. So if the defendant can successfully show that the defendant's crime resulted in some sense from some sort of mental impairment, whether it be mental illness or an intellectual disability that existed from birth, or the result of a traumatic event, perhaps addiction. If the defendant can show that the crime results from some kind of mental impairment, that's traditionally been regarded as a form of mitigation, as something that would justify a more lenient sentence for the defendant. But defendants' claims of mental impairment are often met with a great deal of skepticism by sentencing judges. The concern is a very understandable concern. The concern is that the defendant is just faking it. The defendant is pretending to have a mental impairment for the purpose of getting a more lenient sentence. So what neuroimaging evidence does is that it potentially provides a more objective validation of the claims of mental impairment. So when I talk about neuroimaging evidence, I'm talking about images produced by an MRI or a CAT scan or similar technology. Now, not all mental impairments are things that can be viewed through neuroimaging, but some mental impairments are associated with specific abnormalities that can be detected, again, through an MRI or a CAT scan or similar technology. And now the defendant has something that at least appears to be an objective scientific validation for the claim of mental impairment. There are some concerns about the use of neuroimaging evidence. And for one, as with any kind of scientific evidence, there's a concern that lay people will give it more weight than it really deserves to have. Lay people, and certainly I'm no different, I think, than any other non-scientific layperson. Lay people tend to be fairly impressed by high technology and scientific evidence, maybe more than is justified. I'm no expert in the brain science, but my understanding is that the science actually doesn't provide as much clarity as we might like to have about the link between brain abnormalities that can be visually detected and behavior. So, for instance, if a defendant has a defect, a visible defect with a part of the brain, it may be that other parts of the brain are able to compensate for the area for the injury or damage to other parts of the brain. Another concern that has been flagged with the use of neuroimaging evidence is this: it has been used almost exclusively up to now by defendants in mitigation of sentencing, but there's a concern that it's probably only a matter of time before prosecutors start to use neuroimaging evidence as a basis for aggravating the sentence, for providing a more providing an incarceration sentence or a longer period of incarceration. And the logic there ties back into that point about dangerousness that I raised earlier. Judges are always interested in knowing if a defendant is dangerous and likely to recidivate. And there may be certain brain abnormalities that are detectable through neuroimaging that a prosecutor could use to argue as a basis for concluding that the defendant is more dangerous. For instance, if a defendant can be shown to have an abnormally underdeveloped prefrontal cortex, the prefrontal cortex is responsible for executive management in the brain, and it may be that a prosecutor would argue that this particular defendant is less able to contain impulses of a violent or sexual nature than other defendants, and therefore is more dangerous. So to put it differently, I think that there is a possibility, in fact, I think a real likelihood that we will be seeing neuroimaging evidence used either to complement actuarial risk assessment or maybe even incorporated directly into actuarial risk assessment instruments, and potentially adding to risks or concerns about unnecessary over-incarceration. Okay, let me move to my third topic, and this is electronic monitoring of people who have been charged with crimes or convicted of crimes, electronic monitoring in the community. Now, electronic monitoring of defendants is something that's been with us for decades, but for a long time, this was done with radio frequency technology that actually wasn't very reliable. The years between 2000 and 2010 witnessed a really dramatic change in electronic monitoring technology as we switched from radio frequency to GPS-based electronic monitoring. And so this uses the same technology that you all have in your smartphones. And this is now utilized in those ankle monitoring devices that you've probably seen on TV or in movies. And this allows the authorities to have real-time information about where the defendant is. The advent of this GPS technology really led to an explosive growth in the use of electronic monitoring. The most recent data we have from the States is pre-pandemic, and that showed more than 130,000 defendants on electronic monitoring. And that number is probably far higher today because as a result of the pandemic, there was a real push to reduce jail and prison populations, and an awful lot of the people moved out of jails and prisons were probably moved into an electronic monitoring status. So this is in widespread use, and electronic monitoring in its current form raises a lot of very interesting and important policy questions, public policy questions. For instance, there's the question of how to pay for the use of electronic monitoring, which runs in the several thousands of dollars per year. In the States, there's a big emphasis on getting the defendants themselves to pay for the electronic monitoring, but this is fairly problematic because most defendants are in poverty and are unable, without extreme privations, are unable to come up with the thousands of dollars per year required for monitoring costs. But rather than focusing on some of the interesting issues that arise with current uses of electronic monitoring, I thought you might be interested in hearing about a proposal that was recently made by a group of academics for a much more intensive form of electronic monitoring. It's not in current use anywhere, to the best of my knowledge, but the proponents of this intensive electronic monitoring argue that this could and should fully replace the use of incarceration. So they argue for the complete abolition of jails and prisons and the replacement with this, again, intensive electronic monitoring of defendants in the community. So let me explain how this would work. And the proponents of this argue that all necessary technology currently exists. It's never been combined in this particular way, but they assert that this could be something we do tomorrow if we wanted to. So with this proposal, the monitoring is conducted not through the classic ankle bracelet or ankle monitor. It's done through a harness which is worn on the torso, the supervised person's torso. And it includes not only GPS monitoring, but also cameras, the types of small cameras that are in increasing use in the States by police officers. These are called body cams. So I don't know if this phenomenon exists in Canada or not, but there's been this explosive growth in the last decade in the States in the use of body cams by police officers. So these same kinds of small, lightweight cameras can be installed in a harness and used to provide not only real-time information about where the defendant is, that's the GPS component, but what the defendant is doing. So the idea is that this information would all be fed real time into an artificial intelligence system. The artificial intelligence system would be trained to distinguish between licit and illicit behavior. If illicit behavior was detected, the harness would deliver a warning signal to the defendant to cease. And police officers would be summoned immediately. And if the individual did not cease with the illicit behavior, the harness would then deliver an immobilizing electronic shock using the same technology that's used in tasers, which you probably have heard of. So that's the proposal. Again, not in use anywhere. I think it's a very interesting proposal to contemplate. And I would not be surprised if we see some effort to implement something like this somewhere in the States within the next few years. And And I say that just because of familiarity with the chronic frustrations that we have with incarceration in this country. Number one, it's expensive. So taxpayers are, with good reason, unhappy about the expense of jails and prisons. And number two, because incarceration is widely viewed as ineffective. When people are released from prison, recidivism rates are actually quite high. The latest research showing recidivism rates of about 75%. And so it appears that there's not much actual rehabilitation taking place in prison. So we have this chronic frustration with prisons, and I predict that that will lead to at least some experimentation in this country in the next few years with some form of more intensive electronic monitoring, taking advantage of some of the recent technological developments in areas like body cams. Now, I also anticipate that there will be significant political pushback when there's an effort to first use this technology. It is rather Orwellian, I'm sure you will agree. And so there are some significant civil liberties concerns. So I think we will be having a very interesting debate taking place in this country in the next few years, and perhaps in your country as well. Well, with that, I'd like to conclude my remarks, and I'd be really delighted to hear any comments or questions. And will you moderate the?
Yes, I will.
Okay,
yes,
great.
I will. Yes, I will, Michael. We generally have questions, and we've got a hand up right now. Rod has a question.
Well, first of all, a statement. Monitoring must be cheaper than incarceration. So trying to make the defendant pay for it doesn't seem much sense when the state is saving thousands of dollars by not putting them in prison. But
I agree with that. Yeah.
Could you make a comment about 3 strikes and you're out?
Yeah. So on the first point, just to provide a little, a little more detail on your point about the differences in cost. I think the electronic monitoring is often priced about $8,000 a year. And the average cost of incarceration in the States varies dramatically from state to state, but the range is about $20,000 a year up to $65,000 or $70,000 a year. So definitely big cost savings there. And I agree entirely with your point about how that should make us thankful for the people on electronic monitoring and all the money they're saving us, rather than trying to make them pay for it. On 3 strikes, this is reference to the so-called 3 strikes and you're out laws that were adopted in about half of the American states in the 1990s. Really, they got a lot of attention in the 1990s, but there's really only one state where 3 strikes laws had a big impact. And that's California. And they had an absolutely enormous impact in California, a catastrophic impact in California. By the early 2000s, as I recall the data, more than 1/4 of the inmates in California's prisons were there on 3 strike sentences. And those are very long prison terms. This produced an overcrowding crisis in California. The prisons in California reached a point where there were more than twice as many people in the California prisons as they were entitled to hold, or as they were built to hold. And eventually, federal courts, there was constitutional litigation about this. The federal courts declared the whole California prison system to be unconstitutional, cruel, and unusual punishment because the overcrowding was so bad. As a result of that, there was a court order for California to reduce the size of its prison population, and California adopted some significant softening of that notorious 3 strikes law. Now, it's still a harsh law, but it's not as harsh as it was. And California's prison population, while still larger than it should be compared to the what was designed to hold, is not nearly as problematic as it was. So I do think that the heyday of three strikes is past, and there is a widespread recognition now that those laws were ill-advised, and they led to very long prison terms based on certain inflexible criteria that actually were not related very well to the true recidivism risk of these defendants. So, you can contrast three strikes and you're out. Certainly, it's a very strong contrast to what I talked about earlier, the actuarial risk assessment, which has some data and research behind it.
Thank you.
Thank you. Thank you, Michael. We've got Jim Fairs with a question.
Yes, more of a comment, I guess, Michael. The idea of the harness and electroshock therapy, basically behavior modification is kind of what you're looking at. And I mean, a lot of dog owners use that today. Done properly, it doesn't necessarily hurt anybody, but like you said, it gives a warning. And then, but if you don't respond correctly, there are consequences. The good thing about being a dog owner is that they don't have any civil liberty rights.
Right.
But yeah, it would be interesting to see the ACLU or whoever go after this. Yeah.
No, I agree. And, part of it, there are concerns about the use of the electroshocks. The artificial intelligence systems can be trained to function pretty well, but, they're not perfect. So you have to accept the reality that some people are going to get these electroshocks for the wrong reason. There will be mistakes. It's not, I don't think anybody can claim it's going to be a perfect system. And another issue is that we are talking about true 24/7 surveillance of the individual and all of their actions. You don't take it off when you go to the bathroom. You don't take it off when you go to bed. You don't take it off, period. So that represents a level of surveillance that even most prisoners are not subject to. The closest analogy would be the so-called supermax prisons, which really do subject people to 24/7 surveillance. But those supermax prisons are themselves somewhat controversial in the States.
Okay, thank you. You're good, Jim? Okay, do we have any other questions?
Yes.
Malcolm, go ahead, please.
Yeah, I just I'll give you a comment about how fair is it to adjust a person's sentence based on some mathematical model of factors they don't control.
Yeah.
And say, your blood type is such and such, therefore you will have another couple of years. Or it seems
right.
Speak a bit about that. Yeah.
Yeah, absolutely. That criticism is exactly the criticism that a lot of people make of actuarial risk assessment. I have some real reservations about incarcerating people at all on the basis of predictions of what they're going to do in the future. If you've seen that old Steven Spielberg, Tom Cruise movie, Minority Report, it's like that. It's pre-crime. It's locking people up not on the basis of what they have done, but what you expect them to do in the future. I think there are some real ethical concerns about that. But I start from the position, at least for my remarks today, I start from the position that, look, whether we're comfortable with that or not, that's been with us for centuries. And it's probably unrealistic to expect judges not to engage in that exercise of trying to figure out, is this person dangerous or not? And, if we start from the assumption that that's always going to be part of the sentencing decision, I would rather have that done on the basis of the best available research rather than on gut instincts, because it's going to be more accurate if it's data driven. Whatever reservations we have with like this pre-crime idea and locking people up on the basis of what they might do in the future, if you don't like that, you should, but you think that it's going to be with us forever, you should at least want it to see that done in the most accurate way possible. So that's my take on it. But that's a really good comment, and I've heard many other people who have studied risk assessment make very similar comments.
Hi, I have a question, David.
Yeah, hey, David.
Yeah, hi. Have you ever appeared as an expert witness in court, and what was your experience, if so?
I have not ever appeared as an expert witness in court. I, you know, and I think maybe you're wondering about, like, on the actuarial risk assessment piece. I have studied that. I consider myself more knowledgeable about that than your average commentator. But I'm not a social scientist, and I don't have a deep knowledge of the technical aspects of the way the risk assessments are prepared. So certainly experts are called sometimes to challenge risk assessments, but it tends to be people who are the real data cruncher types themselves, which I'm not.
Okay, thank you. Does that answer the question, David?
As expected, yes.
Okay, thank you. So John Donovan, one of our members, has a question, and I'll read it out for him. Do you have any comments about mandatory minimum sentences and the resulting limits on judges' discretion?
Well, that's an easy one. I strongly disfavor mandatory minimum sentences. That 3 strikes and you're out law that we discussed earlier is an example of a mandatory minimum sentence. So these are laws that are quite commonplace in the states that require some minimum prison term, a year, 5 years, 10 years, whatever, for doing certain things. And these laws are normally generated in election years, and it's really about politics, not science or policy. They're usually thoughtless, knee-jerk reactions to something that is in the news and making people upset. But it certainly has a tendency to lead to over-incarceration. I have some reservations about completely unlimited judicial discretion, and I think those kind of gut instinct decisions by judges can be infected by things like, you know, racial bias or you know, other things that are not appropriate guides. But I would much rather have the sentencing decision made by or made on the base, made by a judge with discretion than made by politicians on the basis of whatever it is that the body politic is upset about. And in answer to the question about whether Marquette is still a basketball power, yes, but not as much as I would like to see. Marquette did qualify for the NCAA tournament this year, but was eliminated in the first round, eliminated by the team, North Carolina, that went on to win the championship. So that takes a little bit of the embarrassment out of the first round loss, that, you know, we know that that was a high quality team that beat them. But hopefully next year, we're hoping for better things next year.
Well, no pun intended, but thanks for being a good sport about that question. Deborah has a question. Deborah?
I'd like to know what your comment, how you feel about this. We had 18 femicides here in Quebec just in 2021 alone. And as of this spring, abusers will now have to wear a monitoring bracelet in Montreal. And as of 2023, all abusers will have to be wearing their monitoring bracelets. And I was wondering how you would feel about domestic violence in particular, having to wear these bracelets.
Yeah, well, that strikes me as potentially an excessive knee-jerk reaction to what sounds like a terrible problem. And it sounds like maybe in Quebec you're experiencing some of the, you know, what has also been witnessed in the States with the pandemic and people being locked in their homes for long periods of time. There does seem to be a real uptick of domestic violence in the States. It's terrible, and, you know, again, it sounds like maybe you are seeing a similar phenomenon in Quebec. I'm not sure electronic monitoring is a helpful response to that. Electronic monitoring, and it has been shown to be somewhat effective, not 100% effective, but somewhat effective in reducing recidivism. But the reason that it's effective is that it's a deterrent. We can tell if a crime is committed and there's a question about who committed it, we can tell, was this particular defendant there or not, because we have this, this record of where they were. So that, but the domestic violence cases, there's usually less of a question of, was the person there at the crime scene when the crime was committed, and also I think that the electronic monitoring is probably more effective at deterring premeditated crimes, and I think that. I'm not an expert in domestic violence, but my sense is that very often the domestic violence incidents are sort of rage-induced and not so much pre-planned. I know sometimes they are pre-planned, but maybe less so than some other kinds of crime. I don't know, is that responsive to your question?
Apparently the women have also an electric thing so that they know when the men are close to them, so that the police officers will know.
Okay.
So
that's okay. So that's a little different use than the standard use. So that's not just alerting police officers. That's alerting prospective victims. And certainly, I wouldn't want to require a victim to have to be hooked up to a monitor, because that can be uncomfortable and inconvenient. But if the victim chooses to have that kind of monitoring, that does sound to me like something that could be quite helpful. I tend to be skeptical of anything that's sort of an across the board, inflexible rule. And so to say that everybody involved with domestic violence has to wear a monitor, that seems to me maybe misguided and potentially leading to the expense and inconvenience for a lot of people for whom there's not really any benefit to having electronic monitoring.
thank you.
Thank you, Michael. Are there any other questions? Maybe a last one, if there are any? No? Okay. Well, Michael, thank you so much for joining us and giving us this excellent talk. David has the honor of giving you a more complete thank you. So David, do you want to go ahead?
Indeed, it is an honor. Michael, we met in 1989. That's 31 years ago. You were truly a wonderful Rotary Ambassador Scholar. And over the years, as you remember, I visited you in your hometown of Milwaukee and even gave a lecture at your university.
Mm-hmm.
I don't say it was the highlight of the year, but it was for me.
It was for me too.
It's interesting, your talk truly, and I don't mean to flatter you, was a remarkable one. We generally think that a judge, when he gives a sentence, is doing, as you say, his gut reaction. Now we realize that the judge has or should have scientific evidence to temper his judgment, either higher or lower in the risk assessment of this of the defendant. So thank you very, very much for your remarks. It truly was illuminating. And I'm not surprised that Time magazine quoted you recently as an expert in this area. Congratulations, Michael, and thank you again for joining us.
Great, thank you. Really, my honor to be with the group as a whole, and my honor in particular to hear your voice again, David. It's been a few years, so I'm really delighted to hear you say, and thank you very much for your concluding comments.
I have one other remark. It reminds me of the four-way test. Is it fair? Is it beneficial to all concerned? So this deals with sentencing. Is it fair to the accused? Is it fair to the society? Is it beneficial to the accused and to society?
Absolutely. I couldn't agree with you more.
Well,
thank
I'm
you
glad
so
to hear
much.
that.
Thank you, Michael. Thank you, David. We will stop the recording now.